The motion that's before the court today, that being the motion on parenting time, custody, and child support on behalf of my client, because the issue of custody really was not addressed in the previous motion filed by Ms. Boone, and we wanted to preserve that issue. Currently, the only order that's in effect before these parents is...
All right, guys, buckle up because this moment instantly sets the tone for everything that follows. The father's attorney starts by laying out a very serious concern. The dad hasn't had any parenting time with his child for months. In family court, that's not a small issue. It goes straight to the heart of the child's relationship with both parents. The lawyer calmly reminds the court that the standing judgment already suggests parenting time should be split evenly. But the real tension here is that despite that expectation, the father hasn't seen his child since before Halloween. That gap raises questions, and in family law, long gaps like that can quickly become a major point of concern for judges deciding what's best for the child.
One that does speak to parenting time, but it's a judgment of support, which would provide that parenting time would be evenly split, 182.5 overnights per each parent. Now, there remains the issue, and it's very concerning to my client, is the fact that he hasn't had any parenting time with the minor child since before Halloween this year. We've been working through the court system. We want to get everything in place. We need to get a custody order in place. We need to get a strong parenting time order in place. But ultimately, we're extremely concerned about the lack of participation by Ms. Boone with parenting time. Now, I would note that the last time we were before you did state that parenting time was to be reinstated, that Ms. Boone was to cooperate with my client.
And if she didn't, the consequences would be that could be used against her in the parenting time assessment.
Yeah,
because that is one of the main factors. And if there's not,
now watch how the attorney begins building the case step by step. He explains that the reason they filed this motion is because the earlier filings didn't properly address custody. In legal strategy, that's crucial. If custody isn't clearly defined, disputes over parenting time become inevitable. The lawyer emphasizes that his client has tried to stay involved and has even provided records showing financial support and involvement since the child's birth. What he's really doing here is establishing credibility. Courts look closely at patterns of responsibility, communication, and effort. By highlighting these details, the attorney is essentially telling the judge, this father isn't absent. He's been trying to participate, but the situation keeps hitting roadblocks.
that also can switch custody if she's not careful.
Yeah, no, I gave Andrew multiple times as I sent it to you.
Well,
for him
I'm gonna get to
Maddie.
Allison. I'm gonna get to you in a minute. Let Mr. Bancroft finish first, and then we'll get to you. Okay.
I'm sorry.
I would state that my client has made himself available, has communicated with Ms. Boone regarding parenting time. She has not cooperated with that. As a matter of fact, when we were before the referee, just within less than a month ago, this issue was addressed then, and it's the same thing. She's stating that he's available, but it has to be completely on her terms, and that it's not to include overnight. She even suggested that it would be some sort of supervised parenting time at that, which had previously never been a factor before. Right. We have provided several pieces of evidence, including medical records, proof that my client's payments for the child, that being involved with the child since the child's birth.
Right.
Here's where things start getting more intense. The attorney reminds the judge that during a previous hearing, the court clearly warned that cooperation with parenting time was expected. And that warning matters. When a judge tells a parent that refusal to cooperate could affect custody decisions later, it's not just casual advice. It's a signal that the court is watching closely. The lawyer claims the mother has been controlling access entirely on her own terms, even suggesting supervised visits despite no prior concerns that would justify that level of restriction. In family court, suddenly demanding supervision without documented reasons can raise eyebrows because it changes the dynamic of a parent-child relationship without formal court approval.
Just witnesses, identification of the witnesses. We're ready to move forward with an evidentiary hearing in this matter. And quite frankly, I'm trying to find a way if there was something we could get some teeth behind that we could file a motion for show cause against Miss Boone for her violation of the parenting time. Granted,
What
it's kind of
court
an
order-
oddball
There is no
situation with the.
Hold on, what court order is she in violation of?
Well, the judgment of support, the one where it does
Which says that it's by agreement.
yeah.
She's in violation of no court order.
And
There's got to be an
that's the-
agreement. Yeah.
And that is the problem, and that's why we haven't done that yet, and why we want to take these steps. But we want to, as expediently as possible, get to a position where we have an order in place, so we can find the best interests of the child, and my client can start exercising parenting time again. Thank you, Your Honor.
Yeah,
This
But now the judge steps in and redirects the entire conversation. Instead of focusing on accusations, the judge goes straight to the legal foundation of the issue. Is there actually a court order being broken? And that's a critical question. In court, frustration alone isn't enough. You need a clear order that someone failed to follow. When the attorney admits the parenting arrangement was based on agreement rather than a strict order, the judge points out the legal reality. Without a specific order, enforcement becomes difficult. This moment shows how family law often depends on precise wording in court documents. Without it, even serious complaints can be harder to act.
this motion is kind of premature. Until we get the front of the court report, we're not doing anything. I mean, otherwise, why would I have sent it to the front of the court?
I
And I
understand.
sent it for legal custody, parenting time, and child support, which, as I explained then, pursuant to a case law, Sims versus Verbrugge, which is a Kent County case that reviews these orders, it does note that physical custody has already been awarded by court order. Even though it was without prejudice, you'd still need a change of circumstance in order to grant a custody request. But you didn't need one for legal custody because this court order does not address legal custody. So, this court sent it for legal custody, parenting time, and child support because obviously that's what it needed to do. And so this motion is premature. I did not find a change of circumstance then, and I do not now. Without further information, I want to see the front of the court report. Let's see what that does first. The quickest way you're going to get to that is if there's an objection to the front of the court, then we grant a hearing. But I'm not granting anything until the front of the court report because you may both like it. You may both hate it. They do settle about 80 to 85% of our cases.
Now the judge explains why the motion might be premature. Before making major decisions about custody or parenting time, the court wants input from the friend of the court investigation. This process allows neutral professionals to review the situation, talk to both parents, and recommend arrangements focused on the child's best interests. The judge makes it clear that many disputes are resolved once those recommendations come out. In fact, a large percentage of cases settle at that stage. It's the court's way of gathering more information before stepping in with a final decision that could shape a child's daily life.
This is because what comes out is normal. And I always warn people, physical custody is a name. I can grant him physical custody and grant him 0 overnights. If you want to know what physical custody is defined at. What's important is parenting time. Okay? Parenting time is when you get to spend the time with the kids. So I can grant you every other weekend and say you've got physical custody. Heck, we used to play with it too and say you got primary, you have secondary. What does that mean? Not sure. Okay, because what matters is legal custody. Legal custody is what entitles you to certain things. That's automatically granted to a husband and a wife. It's not necessarily granted to a child born out of wedlock and the father. What happens under the statute is if you sign an affidavit of parentage, on that affidavit you have presumptively given the other side legal and physical custody, and you signed it as a contract. But again, it's without prejudice, which is why we can review it. I want to...
At this point, the judge gives a surprisingly educational explanation about custody. Many people assume physical custody automatically means more time with the child, but the judge explains that isn't always the case. Courts can technically award physical custody while still limiting overnight stays depending on the situation. What truly matters is parenting time, the schedule that determines when each parent actually spends time with the child. The judge also explains legal custody, which involves decision-making authority over major issues like education and medical care. This clarification highlights something many parents learn the hard way. Custody labels matter far less than the detailed parenting schedule attached to them.
Get something started. I want to get the parenting time going. And as I warned her before, that can be used against her. So I suggest both of you keep what you've attempted and all the paperwork, all the text and stuff. You might want to print them out because they may become relevant as to who's doing what. That's why I always tell people keep the receipts on this stuff because it's important. The court may need to look at it. We may not. But I'm afraid I'm going to deny it at this time, Mr. Bancroft, without prejudice, because we need to get, you're right, we need to get moving forward. Unfortunately, I think I also warned you in that November that 7 of our 11 holidays happened between November 11th and January 13th. So the court generally gets backed up during those 2 months and everything gets thrown up. Just put out about 4 or 5 weeks. So you should be getting that report. When did you meet with the front of the court?
The 8th of January.
Okay, so give them about 4 weeks to 5 weeks and they'll type up the recommendation. They will send it to you. If you both agree with it, it will become a court order. If one of you objects to it, we will set a hearing. Okay? As a matter of fact, if that hearing needs to be set, let me see if I can circumvent this one. File your
Now the discussion shifts toward how the legal relationship began. The judge explains that when a father signs an affidavit of parentage, it creates a legal presumption about custody arrangements, but it can still be reviewed later. That's why the court wants the investigation completed before making changes. The judge also encourages both sides to keep records of communication, texts, messages, schedules, because documentation can become extremely important if disputes continue. In family court, written records often carry far more weight than verbal claims. The message here is clear. Keep track of everything, because the details may determine how the court evaluates cooperation between parents.
Whoever wants to object, file the objection, contact my clerk, and we will just automatically set it for a hearing. You don't have to come in for a motion like this. But it has to come with this, Allison, because I can tell you this morning. If we do go to a hearing, you will be treated like an attorney. Okay? We're going to talk about, at some point, we're going to talk about who would go first, and it depends on what's being recommended and who is objecting. So we'll make a determination as to who goes first. You'll be allowed opening statements, which is basically, welcome back to English class. It's a summary of your paper. I need the bullet points, the topics, and then you'll be allowed to present witnesses. Evidence comes into court through a witness on the witness stand. Evidence does not come into court as a stack of papers. Each paper has to be reviewed by a witness under oath, said, hey, I drafted this, or I got this off the internet, or this is what my research, mark it as Exhibit 1, any objections, then it gets entered into evidence. Otherwise, the court does not look at it. To give you an example, I had somebody that presented 18 exhibits about 6 months ago. They entered 4 of them. And when I made my decision, they were like, well, why are you making that decision? What about? And I'm like, you never entered that into evidence.
Okay, yeah.
The court never saw it.
Okay.
So please understand that my abilities are limited by the testimony that you give me. I can only make a decision based on what you guys tell me.
Now the judge gives a detailed warning about what happens if the case goes to a full hearing. The mother, who is representing herself, is told she will be treated just like an attorney in court. That means presenting witnesses, introducing evidence properly, and following strict rules about what information the judge can consider. The judge even explains that documents cannot simply be handed over. They must be introduced through testimony under oath. This moment highlights how formal court procedures can be challenging for people without legal training. It's a reminder that family court may seem informal on the surface, but the rules of evidence still control what the judge is allowed to consider.
In court, which is why we do the front of the court first, because they can hear all of your stuff. Hearsay rules do not apply. The rules of evidence do not apply. They get to hear everything, see everything. Whereas if you're in court, you either may forget to give me it, or it's not admissible because of certain rules. So yes, my decisions can be very limited.
What would be admissible, be considered admissible? Like, can you give me an
That
example?
I can't give you 3
Okay.
years of law school and a
Okay.
5-minute
Okay.
master's.
Okay.
And this,
I'll
Mr.
figure it
Bancroft will be
out.
able to. Yeah, Mr. Bancroft can talk to his client about this, but that's why I need to talk to you, because that's what warning this comes with. Is if we go to court for a
Oh,
hearing,
I'm sorry.
you are treated as an attorney.
I
We'll
do.
discuss we would discuss whether you guys would want that hearing in person or on Zoom. That's up to you. I do it either way. So far, 90% of the people prefer it by Zoom because it's just easier for everybody. They don't have to drive down to the courthouse. They don't have to have their witnesses come down. Their witnesses can just call in. So that makes it a little bit easier. All right. I might suggest that you consult an attorney, though, Ms. Boone.
Yeah, I've been talking to one.
Yes, Mr. Bancroft.
I know it's probably not necessarily appropriate to use this setting, but we do have the parties all in one spot between you. May I inquire of Miss Boone regarding trying to set up a parenting time session at this point?
Yes, you may.
Miss Boone, today's Friday. Would it be possible for Andrew to pick up Maddie at 6 p.m. tonight?
No, but he can stop by whenever. Whenever I'll make it available, he can stop by anytime.
Well, isn't 6 o'clock anytime?
Yeah, he can come by, yes, but he cannot. I don't want him to pick her up right now.
Why?
Because he doesn't have to give her back to me.
And finally, the judge tries to steer the conversation toward a practical solution. The father's attorney asks whether the child could be picked up that evening, but the mother hesitates, worried that the child might not be returned. The judge reassures her that legally she still has authority at this stage, while also warning both parents about the consequences of refusing cooperation. If the father failed to return the child, that would hurt his position. But if the mother blocks all parenting time, that could also weigh heavily against her later. The judge ends by encouraging them to reach an agreement outside the hearing and even offers a private discussion room to work out a schedule. Because in family court, cooperation between parents often matters just as much as any ruling from the bench.